All right, payment bonds. You are not allowed to file a lien on public property, a mechanic's lien. Somebody asked that question at lunchtime, and it's a very relevant question. It's the same as suing the government. You can't just sue the government. You cannot sue the government unless the government has agreed it can be sued. It's called sovereign immunity. It's the king is immune, the government is immune, and it's a good rule whether you understand it or not. I can tell you it makes perfect sense to me. The Contract Disputes Act is an example of a waiver of sovereign immunity. The government just says in the Contract Disputes Act that if you have a contract with the government and the government breaches that contract, you're allowed to sue them. That's a waiver of sovereign immunity. But there's no such waiver under mechanics lien statutes, and the government takes a dim view of people like me filing a mechanics lien on elementary schools or on post offices. They don't want me to do that, and they don't want me foreclosing upon those public use buildings, and so I'm just not allowed to. You have something better as a general rule. And we talked about the first mechanics lien statutes and the purpose. This was very similar. There was a problem with public works. GCs were having trouble getting subs and suppliers to bid on them. Nobody wanted to work on public projects because it was risky. They didn't have mechanics lien rights. And if their debtor became bankrupt, they weren't going to be able to collect, and that was a problem. As a result, in the 1930s, well, there was an earlier act called the Capert Act, but that became what we now know as the Miller Act, and that was from 1935, so we're almost coming to the 100-year anniversary of the Miller Act. You don't have mechanics lien rights, but you have something better, payment bond rights. It is, we talked about the 3 slides. You have your contract debtor, you might have security rights in a specific piece of property, or you may have a personal guarantor. A payment bond is one of those. The only difference is rather than an individual who happens to be the president of the company signing your personal guarantee, it's hopefully a big insurance company. But to jump straight ahead to one of the biggest issues in this subject area, just like the president, individual president of the company, a bonding company might be insolvent. Your payment bond rights may be of no value whatsoever, and that's something you have to be able to recognize. Is this a solvent bonding company? There's usually no defense of payment to a mechanics lien. You can make the bond company pay twice, even if your customer has been paid in full. There are only 2 exceptions to that I want you to remember. One is in Pennsylvania. That's only been true 5 years, but for reasons I cannot possibly explain to you, the Pennsylvania Public Work Little Miller Act says that once the GC pays a sub in full, nobody below that has bond rights. It's the only state I know of that that's true. Enforcing bond rights is cheaper and easier than mechanics lien rights. That's why you'd rather have them. We've spent a lot of time talking about how mechanics lien rights are a battle between innocents, and that's why you get all these technical, complicated arguments, and why your legal fees are so high, and you have to do a title search, and you guys are tired of hearing that, and I'll know you'll remember it. But the point is, bonds aren't that way. Bonds are pretty simple. They're not complicated. Your legal fees are going to be a lot lower. Parts of it you can do on your own. You don't even need a lawyer. It depends a lot on how much you're owed. You know, if you're owed a lot of money, you want some help. But especially for smaller dollar amounts, it's not a big deal. And even more important, I mean, there's usually no defense of payment. So I'm going to collect your money. I look good. I seem like a hero. I bill you a relatively small amount of money. I collect your money. I give it, even if your customer is bankrupt, even if they've been paid in full, I'm going to collect your money. It's a lot harder to screw up a bond claim than a mechanics lien claim. It's a lot easier to defend a mechanics lien claim because it's more complicated. All right, the Federal Miller Act is the mother of all bonding statutes. The contracting officer on any new construction contracts must require, that shouldn't say must provide, it should say must require the payment bond. It's the GC that provides the bond and the surety. The contracting officer requires them to get a bond. All right, types, you got bid bonds, performance bond, payment bond, mechanics lien bond. It's in the book. I'm not going to get into it. It can get confusing, but what we're talking about here today are payment bonds. They often travel with these other type of bonds, but we're not talking about performance bonds today. Okay, federal operates under the Miller Act. State, county agencies, the local school board, etc., they operate on what is usually called the Little Miller Act. And that's because it's patterned after the Miller Act. Sometimes it's identical. The DC Little Miller Act is identical to the Federal Miller Act. More commonly, they're very similar but have some differences. That would be true of both Maryland and Virginia. And before I forget, that's part of what makes it possible, because we're really marching through one chapter. So if you want to, you can go to chapter 14. And we're just kind of working our way from page 14.3, we're kind of working our way through that. And you also have, we'll get to that appendix 33 later, which is the differences between the states. All right, one of my big mantras you're going to hear me say over and over and over again is private bonds are open season. This is one of the biggest areas of misunderstanding and mistakes amongst lawyers and especially amongst clients, that somebody like you is going to think, well, I know how bonds work. You know, there's no defensive payment on a bond. Well, sometimes there's bonds on private projects. You need to know if there's a bond on the private project. That's one subject we kind of talked about earlier. That's part of qualifying the project that you're going to lend $100,000 to. You want to know if it's bonded, and you want a copy of the bond, and you're more willing to give better credit terms or perhaps even give a better price if it is bonded. But you also want a copy of the bond on a private project because you have absolutely no idea what the rules are unless you read that bond. If I'm representing the general contractor, which I often do, as often as I can, and I'm working on a private project in Virginia, but the owner's going to require, normally they want to require a performance bond to make sure that the project's going to be completed. That's what a performance bond, only the owner has a claim under the performance bond because you failed to complete the contract. And the payment bond just kind of comes with it. Single premium, no extra money charged by the bonding company. They issue the performance bond and the payment bond. And if I'm representing the GC, I go and talk to the owner and I say, owner, I understand why you wanted the performance bond. You got to make sure the project's completed on time and according to plans and specs. So that's fine. We'll give you this performance bond, but let's talk about this payment bond a little bit. This is a private project. So the reason you want this payment bond is because you're worried about subs and suppliers. You're worried about Charlie here filing a mechanics lien on your project. That's what you're worried about, right? In Virginia, there's a defense of payment. Once I pay, once you pay the GC in full, or once I pay my sub in full, nobody's going to have lien rights below that. So let me write this payment bond that it reads the same way. Once my client, the GC, pays the sub in full, nobody has mechanics lien rights and nobody will have bond rights either. And that can't possibly hurt you, owner. So you should let me agree to that. And owners will often agree to that. And it is effective. There may be a defense of payment on a private bond. You usually have 90 days to give notice on bond rights. I've written payment bonds on private projects where it says you got to give 60-day notice within 60 days instead of 90 days. A very commonly used form, the AIA contract forms, we've talked about a couple times. AIA does payment bond forms also. One of the most commonly used payment bond form says that within 90 days, you have to give notice to any two of the three following: the owner, the general contractor, or the surety. But you got to send two notices to any two of those three within 90 days of your last work. And I've had this case. If you have that on a public project and that's the bond form, I argued to the court, well, wait a minute. The Virginia Little Miller Act says that I only got to send notice to the general contractor, and I understand this bond form says I got to send notices to different places, but how would I know that? Nobody gave me a copy of the bond, and the owner and the surety and the GC are not allowed to agree between them to limit the rights the General Assembly of Virginia gave me for working on a Virginia highway project. They're not allowed to do that. My bond rights are preserved if I followed the statute. And the court ruled correctly. I mean, it's the only possible answer. That's correct. As long as Fullerton gave notice in accordance with the statute, it doesn't matter what the bond form says. But if you had the same facts on a private project, I would have lost. Because it's whatever everybody agrees to. So that's what I'm going to do. If I'm representing the GC, my payment bond's going to say you got to give notice within 60 days to any two of the three following. And once I've paid my subcontractors in full, nobody has any rights under this bond. So private bonds, bottom line, you must get a copy of the bond to know that it is bonded, and you must get a copy of the bond so you know what the rules are. Whenever I know the sub has a bond, that means to me almost guaranteed the GC has a bond too. And so that comes in this form. I might write the GC a letter that says, my client's on a project, they haven't been paid, we're working on a mechanics lien. Next thing I know, this happens regularly. I receive a letter from the GC saying, oh, thank you for your letter. Fortunately for you, we required subcontractor payment bonds for your protection. Here's a copy of that bond. You, rather than file a mechanics lien, you should go enforce your rights. This gives me a good opportunity to say that when that happens, the little light goes off in my head, and I'm going to do two things. The first thing I'm going to do is go file a mechanics lien, because I know they're worried about that, and there's a reason they don't want me to do that. And the next thing I'm going to do is send a bond claim notice on the general contractor's bond, because the fact that they required a sub bond makes me absolutely confident the GC has a bond also. And I send a notice on the GC bond, and that's as a general rule. You do not need to know whether there's a bond to send a bond claim notice. Anytime you're not getting paid, send a project demand letter just saying, this is a claim on the payment bond. Send me a copy. And you're preserving your rights. That's sufficient, as we're going to talk about right now. That preserves your rights under the payment bond, if there is any, and you have another 6 or 9 months to figure out whether there is a payment bond. But you've sent the notice. All right, most government jobs require bonds except little projects. Maintenance contracts can be a problem. I remember having a case, but 20 years ago, all of the HVAC units on the roof of the Pentagon were replaced. I mean, that was a multi-million-dollar contract. No payment bond. That was a maintenance contract, not a construction contract. So it's just something you got to watch out for. New construction. Quasi-government job. PP3s are the big battleground now. Private-public partnerships. The toll lanes down the middle of the Capitol Beltway, which is in my territory, right by my mother's house, where I think I'm going right after this seminar, is right next to the Beltway in Annandale. And out in the middle of the Beltway, there's toll lanes. And I had a client, a stone supplier, that was supplying stone there, and they knew it was bonded. They didn't need a copy of the bond. They know it's bonded. It's a public project. There's absolutely no doubt those toll lanes were on public property. It was in the middle of the Beltway, for Christ's sakes. But it was not bonded. The owner of that project was a private company, Floor Lane, and that's who is collecting your tolls. And people want to know why the tolls are so high. That's the answer to the question. It's not publicly owned. It's privately owned. The government owns the dirt, so you do not have mechanics lien rights, but the structure, the lanes, are owned by Floor Lane, not by the government. So no bond was required. Now, usually there is a bond, but that's just an example of where you got to be careful. PP3s, quasi-government jobs, where the government's a tenant and not the owner. I represent HIT Contracting, for example. They had a project one time, the new Sallie Mae headquarters in Tyson's Corner. And there was a huge sign out front, new headquarters for Sallie Mae under construction. And it occurred to me, I mean, this didn't happen, but it occurred to me, you know, somebody might just assume that's a bonded job for that reason, but it wasn't. The government had like a 100-year lease. And the project, the building and the dirt was privately owned, so there was no bonding requirement. So again, this is all I'm saying over and over and over again. What it comes down to is you need to get a copy of the bond and see it to know for sure what the deal is. Okay, so this is on chapter 14, page 38. These are places you can get free qualifications, credit reports on the bonding companies. You guys have heard of Moody's, Standard & Poor, Best. They all rate bonding companies. Just go on the website, type in the name of the bonding company, boom, there it is. Absolutely free. If it's a big company you've heard of, Travelers, you know, you're going to be fine. But if it's somebody you never heard of, you need to be nervous. And even if it's a bigger job, you know, it's just a good habit to get into. Just click it in there. And this is on page 1438. Forget whether I said. You just want to get in the habit of checking that. Here's another true story. I sued a bonding company one time with an address in Florida on a public project in Virginia. I had to get a private process server to serve the lawsuit in Florida on the bonding company. The private process server gave me a call when they attempted to serve that lawsuit, I think mostly because he thought it was humorous, and it was kind of humorous. But he said, well, we got a problem down here in Florida. The address you gave us for this bonding company is a boat slip in a marina, and your ship has sailed. That's an absolutely true story. I'll tell you another true story. Lewis Heights on Fort Belvoir, which this is near and dear to my heart because I was born at Fort Belvoir in the hospital that used to be across the street from Lewis Heights. But Lewis Heights is red brick apartments that are for specialist enlisted persons. And there was a contract to completely renovate these buildings. And there was a bond. The client confirmed there was a bond on these projects. And it might have been a maintenance contract, so they were smart to confirm there was a bond. And of course, nobody got paid. The GC didn't pay anybody. So now we're all lined up at the federal court in Alexandria on preliminary arguments of some type or another. And it turned out that the surety had shown a financial statement with thousands of acres of real estate in West Virginia, and that was how they convinced the contracting officer that they were a sufficient surety to provide a Miller Act payment bond and performance bond. Guess what? I forget the people's name, but they lived, I used to know their name. They lived right, well, the thousands of acres of real estate were what you would identify if you did a Google map as being Canaan National Forest. They didn't own anything. This was fraud. My point is, that's your problem. You do not have the right to sue the government for failing to do their job. If the government forgets to require a bond at all, that's your problem. If the government accepts an inadequate surety who becomes bankrupt, that's your problem. That brings us back to sovereign immunity. You cannot sue the government for failing to do their job. You can sue the bonding company on a bond that is provided. So again, there's no substitute for getting a copy of the bond. Look at the financial strength of the bonding company. All right, who has protection under the bond? Subs and second-tier subs have bond rights. So here's the bond principle. So it's like mechanics liens, except the owner has nothing to do with it. This is the owner, in a sense, on a payment bond, the prime contractor. Anybody who has a contract directly with a prime has bond rights. Anybody that has a contract with a sub has bond rights. Everybody below that is cut off, whether they're a supplier or a sub. Now, jumping ahead, well, not really jumping ahead. The next thing I want to point out is that a supplier to a supplier never has bond rights. Okay? This is on page 14-4 of the book, if you want to see it. A supplier to a supplier never has bond rights. This is a big impact for a subject we did not talk about today. That's doing business with disadvantaged business enterprises. If you're a material supplier, but your customer is not an on-site sub, they are only a supplier. There's a lot of DBE suppliers in the world that all they do is mark up the value of your invoices by 2% and pass the invoice on to the sub. And you need to worry about the creditworthiness of such DBE suppliers. You're probably familiar with that. What I'm saying is that on top of that, you do not have bond rights because you are a supplier to a supplier. One of the most common, and I have been surprised myself how much luck I've had calling that GC and saying, I understand you have minority or disadvantaged business enterprise participation requirements. I understand 26% of this contract has to be completed by DBEs, but if I was here, I would have bond rights, and since you inserted this guy here, I no longer have bond rights, and that radically changes my creditworthiness. So you're either going to have to pay me in advance or give an amendment to the bond. It's called a rider or an endorsement to the bond. The bonding company has to sign it, and the GC has to sign it, saying, notwithstanding any other provision of the Miller Act or the bond, Triad Metals shall have rights under this bond for all materials supplied to such and such project. I'm not sure I've ever had that fail. I mean, I don't do it every day, but I think every time I've ever done that, I've succeeded. And it surprised me, to be honest with you, but both the GC and the bonding company would sign the rider and send it to me. The other thing, and then you're just as good a position as if the DBE wasn't there. The other thing you can think about that is not as good, but it's a stopgap measure, is get an assignment of the DBE's bond rights. And this is common, not just in bonds, but with any questionable customers that you have. One thing you can think about is saying, I'm not going to be able to sell to you unless you assign your lien and bond rights to me. If I don't get paid, I'm allowed to file a mechanics lien in your name on this project, or I can make a bond claim in your name, and I can enforce payment, and I'll receive money, and if there's any money left over after my receivable is paid, I'll give it to you. That's not perfect. You can have problems with that, but that's a choice. You don't need the GC's agreement, is one advantage to that. Your DBE can agree to that. Material not actually used. I think I mentioned earlier, this is a big difference between mechanics lien rights and payment bond rights. You do not have mechanics lien rights if that lumber is sitting in a pile on the parking lot. It is not permanently annexed to the freehold. It is not part of the real estate. You do have payment bond rights for lumber sitting in the parking lot. Big difference. Similarly, here's the scary part for a GC. I do a lot of bond work for GCs too, but it's defending performance bond claims against the owner, and it's defending payment bond claims against you nasty suppliers with your file and bond claims on my innocent GC client's payment bond. And one of the most frightening things in the world for a GC, I mean, what I spend all my time talking to GCs about is you got to police this stuff. You got to make sure all the suppliers are getting paid. You have to require copies of waivers from the suppliers, because here's what can happen. And here's one of the things that can happen. There's a good faith rule. If the debtor diverts the materials to another project and you have a good faith belief that your materials are going to this bonded project, you still have bond rights, even if the debtor diverted the material to another project. You think about that for a minute from a GC's point of view. They're not even aware this is happening. They supplied a payment bond on the project, and then the debtor, have you ever cut off a debtor before, Charlie? You have. I knew you were a mean guy. You cut off a debtor, you wouldn't supply any more material. Next thing is maybe that debtor comes into your office and says, Charlie, I understand why you cut me off, but you and I have been friends a long time. And look, I got this new federal project, and look, here's a copy of the payment bond. You'll supply me on this project, won't you? Let's play truth. How many people have agreed to that? Most credit managers will. What I'm telling you now is that maybe you got to notice, or maybe you have noticed, it's amazing the volume of materials that debtor's using on that project. You never would have thought they needed that many. those materials are going all over the state, right? If you have a good faith, reasonable belief that you are supplying a bonded project, you have rights on that payment bond. As a GC, that is frightening. You have to police it. You have to know Charlie's on the job. You have to have a list of all subs and suppliers on the job, and you gotta insist on waivers from Charlie at every progress payment is the only way you can protect that. And that's the significance. You've probably seen a contract term, no other suppliers or subs allowed on this project unless you accept what's on your list. That's why they care. And it's a very legitimate need. And I tell them, everybody else, you got to see a waiver from, and if they didn't supply any material that month, they shouldn't have any problem giving you a waiver. I need a waiver from everybody on this list each and every month, or I'm not paying you anymore. Sums justly due. We're doing pretty good on time. The Federal Miller Act payment bond is for all sums justly due to Charlie on this federal project. If you think about it, those words are focusing on what is contractually due to the claimant. The federal courts have consistently ruled that if Charlie has a credit agreement that says he's entitled to legal fees and 18% interest, those are sums justly due to the claimant, contractually due to claimant. I use the old words. The wording has changed maybe 5 or 10 years ago, but you come to the same result, the wording of the statute. It's what is it used to be sums justly due. Now it says what is contractually due to the claimant. So you have bond rights as a supplier, not just for your material, but for your legal fees and your interest. Now you add up the last thing we talked about in this thing, and think about, maybe you GCs back there are already quivering in your seat, thinking about what this means. I hope you are. There's a credit agreement between this supplier and the sub. The credit agreement says 18% interest, and the sub will be liable for legal fees if they don't pay. The GC can pay that sub in full, paid them everything they're ever supposed to. Or maybe that material you supplied went to a different project, but the supplier had a good faith, reasonable belief that it was going to that bonded project. This supplier can not only make the GC pay again, even though they've paid once, they can make the GC pay legal fees and 18% interest. That is frightening for a GC. But it's important for you to know as a claimant, as a sub or a supplier, to know that. Federal projects, that's the deal. And that's another reason to make sure you have a contract that entitles you to legal fees, because here's another place that's going to help you. And 18% interest is going to give you a lot of leverage to get things resolved. And there was, the other big point is about private bonds. I've had this case a couple of times, that bond forms often track the Miller Act statute, like the AIA bond forms do. And bonding agents are just lazy. And their clients, the GCs in the world, are also lazy. And so I spend a lot of time coaching my GC clients, do not get lazy, because otherwise what's going to happen, when you're on a private project, you tell your bonding agent you need a bond. Your bond, they literally have a pad of bond forms, and they just rip off the next bond form. They fill in a couple blanks, they sign it. Here's your bond. That's what they do. And that bond might say, this bond is to protect all persons supplying materials for the performance of the contract For all sums due the claimant, or sometimes the bond forms still say sums justly due, even though the statute hadn't said that in 10 years. And so even on a private project, my argument is, Judge, look at this. This bond says I'm supposed to get paid all sums contractually due to my client. And look, here's 50 years of federal case law that has interpreted those words in the Miller Act statute and decided that my client would be entitled to legal fees and interest. So your job, Judge, is to interpret what this contract, this bond says, and it says I'm entitled to all sums justly due, and you must come to the same conclusion that federal courts have come to interpreting the Miller Act. I've had that work more than once on private projects. So that's kind of the flip. You remember me saying on a private project, you got to watch out for people like me putting more restrictions in the bond. But if you're a GC, I want you to worry about, make sure you do not provide more protection than you have to in the bond. Do not let your bonding agent get lazy. Do not let them use the sums justly due language. And in fact, if I'm representing a GC, I write the bond to say, this bond provides the bare minimum protection required by the Virginia Miller Act and not an inch further. That's a perfectly legitimate way to write a bond, and that's the way the bond principal wants it to read. Form of the notice is a simple test to pass. It's Appendix 31, about 5 pages from the back, a bond claim notice. This is a really simple test to pass. You have to know who you had a contract with. You can do that. You must state with substantial accuracy the amount of your claim. No, I don't know what that means, but I think it means you're allowed to be somewhat wrong in the amount of your claim. I mean, it fairly certainly means that. But so you have to know how much you're owed and you have to know who you had a contract with. Easy. You can do these yourself. If you're owed 100 grand, you probably want to have me do it, but especially if you're owed 5 or 10 grand, and if you're way ahead and you have more time to fix it later, you could think about doing it yourself. Just Xerox this page, fill in the blanks, send it off. The key is you send it to the right place and you send it certified so that you have proof of delivery. Now, you cannot send notice too soon. You cannot send notice too many places. That's how you deal with bond claim notices. Same with mechanics lien notices. The whole purpose is to freeze money. There's no defense of payment on a bond. You can make the GC pay twice, but I've had one of the very common mistake. You hire these young lawyers straight out of law school, and at some point, a few of them have come in my office and said, well, you know, this is a payment bond claim, and the GC's paid the sub in full, but I've done some legal research, and there's no defense of payment on this payment bond. We can make the GC pay again, so we're okay on this. And I'm like, let me get this right. You're telling me that we're going to sue an innocent general contractor and try to force them to pay a second time for materials they've already paid for? Do you think they're going to defend that case? Do you think they're going to try to beat us? I think we have a problem. But if that same GC was still holding money, it's a radically different picture. The whole point is freezing money. In mechanics lien litigation and in payment bond litigation, you cannot send notice to many places. That's why this notice has multiple, it's addressed to the owner, the GC, the sub. If you have 3 addresses, most of the Miller Acts, not private bonds, But all the Miller Acts require notice to go to the GC. That's the most important. The rest of them are not necessary, but it does not hurt. There's plenty of case law. There's case law where the notice was sent only to the surety, but the surety forwarded it to the GC. You have bond rights, okay? You're going to send it by fax. You're going to send it by email. You're going to send it by certified mail. That's partly because there is an actual receipt rule in some states. We don't need to get into it in detail. But federal, for example, they've got to receive the bond claim notice within 90 days of your last work. Postmark doesn't do it for you. They must receive it. So one thing that means is you can't wait till the 89th day. The other thing that means is you got to leave time for delivery. And that's why it was so important they changed the rules. Federal used to say registered mail was your only choice. But there was plenty of case law. If you faxed it and they received it within time, you're okay. But they changed it that any means of third party that has third-party verification, you're okay. What that means is FedEx, they get a signature. Or a commercial courier, they get a signature. You cannot deliver it yourself and say, I swear I delivered it. Anything where a third party is getting a signature is fine. Okay, Virginia is really the same, so I'm not going to get into it. Notice within 90 days of your last work. Maryland is a little different, and so I want to point this out. It goes one tier lower. So a third tier sub or supplier has bond rights. So that's kind of a scary thing for a GC on a Maryland project, but it's a really good thing as a supplier on a Maryland project. You can be pretty remote and still have bond rights. And with most Miller Acts, you got to send your notice within 90 days of your last work. You must file suit within 1 year of your last work. It doesn't matter when you sent the notice. You must file suit within 1 year of your last work. But Maryland, you must file suit within 1 year after the government accepts the project. And if you do much government contracting, you know it takes the government a long time to accept a project. So as long as you sent that notice out, you might have bond rights 2 or 3 years after you supply a project. I mean, I'm not kidding. And if you happen to have supplied the GC directly, where there was no requirement of notice, even though you never sent any type of notice, never sent any type of demand letter, you may still have bond rights 2 years after you supply a project. So that's kind of cool about Maryland. DC is identical as federal, the Miller Act, real simple. Pennsylvania is the same as federal, except it's the only state I know of that there's a defensive payment on the bond. I got no explanation for that. So you need to worry about that on a public project in Pennsylvania. And there's your summary. And there you go. There's me. Thanks for coming. And I had fun.